Last video, I told you something that stopped a lot of people. I told you that the Tesla tiny house, the one they say you can own outright for under $10,000, comes with a lease agreement, and that a real estate attorney with 30 years of experience, when she sat down and read that lease, said she had never seen 3 specific clauses written into a residential agreement before, not once in 30 years. Today, you're going to find out exactly what those 3 clauses say, what they allow, and what they could cost you, not in the next 10 years, in the next 18 months. If you already signed this lease, this video is especially for you. If you're still deciding, you need to watch every minute. I am not a lawyer. I don't have a referral link. I don't have a sponsorship agreement with anyone in this industry. What I have is a copy of the lease, a conversation with someone who has spent 3 decades reading contracts just like it, and an obligation to tell you what I found. By the time this video ends, you will understand 3 specific things. First, what the 3 anomalous clauses actually say, in plain language, not legal language. Second, what each one allows the lessor to do and how quickly they can act on it. Third, what your options are if you have already signed and what you must do before you sign anything. A contract is not what you believe it says, it is what it actually says. Those are not always the same thing. That line belongs to the attorney I consulted for this video. 30 years, commercial and residential real estate. She has reviewed senior housing agreements, mobile home park leases, and manufactured home contracts across 6 states. She read this lease in 2 hours. She called me back the same afternoon. Her first words were, "This is not a standard residential lease." Before we get to the 3 clauses, you need to understand how this lease is structured, because the structure itself is the first thing that should give you pause. A standard residential lease, the kind you sign when you rent an apartment, a house, a room, operates on a fixed term, 12 months, 24 months. Both parties know exactly when it ends and exactly what it costs until that moment. This lease is not structured that way. It operates on a rolling structure.
Now imagine a home
A
that
24-month
powers itself.
free period is the entry point. After that, it converts to an ongoing fee arrangement, estimated at $299 to $499 per month, depending on the placement tier you've selected. But here's what rolling structures do. They place nearly all the renegotiation power in the hands of one party, and in this contract, that party is not you. The attorney I spoke with put it this way: a rolling fee arrangement in a residential context requires that the tenant have clearly enumerated rights, what can change, what cannot, and how much notice is required before any change takes effect. She said this lease enumerates those rights, but not in your favor. The 3 clauses. Clause 1, the operational cost adjustment
Now imagine
provision.
a home that powers
Here is
itself.
what this clause says in plain language. The monthly fee can be
doesn't build
adjusted
houses like
at any
projects.
time to reflect changes in operational costs. That term is not defined in the agreement. There is no cap on how much it can increase. There is no formula tying it to an index, not the consumer price index, not inflation, not any external benchmark. It is discretionary. I want to be precise here. The clause does not say fees will increase. It says they may be adjusted. But an uncapped, undefined discretionary adjustment provision in a lease is not consumer protection. It is the absence of consumer protection. If you cannot tell me the maximum I could owe you next year, you have not given me a number. You have given me an open obligation. That is the attorney speaking, not me. Now, consider your situation. You are 68, 72, 76 years old. You're on Social Security. Your income is fixed. It does not adjust
Tesla
for
doesn't build
inflation in
houses
any
like
meaningful
projects.
way,
No
but your
stress.
lease payment can
No
adjust for
surprise
anything
bills.
described
Just
as
a home that works
operational
with you.
costs, and there is no ceiling on what that number becomes. Over 10 years, starting at $299 per month, a 40% escalation, well within the historical range we've seen in mobile home park leases, which use nearly identical language, brings you to $418 per month. A 60% escalation brings you to $478 per month. At 80%, you are at $538 per month. That is $64,560 over 10 years for a house that cost under $10,000. And you cannot leave without a cost of your own, which brings us to Clause 2. Clause 2, the relocation obligation and cost transfer provision. This is the clause the attorney said she had never seen written this way. In most residential lease agreements, even mobile home park leases, which have their own problems, if a landlord terminates your occupancy without cause, the landlord bears the cost of displacement, or at minimum, the cost is shared. That's standard. This clause does not work that way. Under this provision, if the structure must be relocated for any reason, including changes in zoning classification, changes in the lessor's use of the land, or the lessor's determination that the site is no longer viable, the cost of relocation falls entirely on the occupant, every dollar of it. Moving a Tesla tiny house requires a licensed transport provider, solar disconnection and reconnection, permit processing at the new site, reconnection of the Powerwall system. Depending on distance and destination, certification at the new location. The last video established this range, $3,000 to $8,000. That was a conservative estimate for a planned move. An unplanned move, forced by the provision we just described, is not planned. Transport on short notice costs more. Certified installation at an unverified site costs more. Temporary housing during the transition adds to the total. The attorney's description of this clause was direct. She said, "This is a pass-through liability clause. The lessor has effectively transferred the financial risk of their own land decisions to you. You have no control over the land, and yet you are the one who will pay." You need to sit with that. You are 74 years old. You have lived in this home for 2 years. The zoning board reclassifies the area, something that has happened to 14 residents in California's Central Valley as recently as 2024. The lessor decides the site is no longer viable. The land changes ownership. You receive a notice. You have 60 days, and you owe every dollar of moving that house from where it sits. Now, Clause 3, the dispute resolution and jurisdiction waiver. This is the clause that takes the longest to explain, but it may be the most important one. In standard residential lease agreements, disputes are resolved through local courts, small claims, housing court, or civil court, depending on the amount in question. That matters enormously for a tenant on a fixed income. Local courts are accessible, they're close, filing fees are manageable. You don't need an attorney to show up. This clause requires that disputes be resolved through binding arbitration in a specific jurisdiction, not your jurisdiction, the lessor's. The arbitration process itself costs money to initiate. Filing fees for arbitration range from $200 to $575 just to begin the process. The arbitration proceedings are private, no public record, no precedent, no community of other affected tenants who can reference your case. The arbitrator's decision is final and binding. You waive your right to appeal in most jurisdictions once you enter binding arbitration. There's one more piece. The clause contains a class action waiver. If dozens of other tenants have experienced the same escalation, the same forced relocation cost, the same problem, you cannot join together to address it collectively. Each of you faces the lessor alone. The attorney's words on this clause were, "Class action waivers combined with private binding arbitration are increasingly common in consumer contracts. I have not seen them paired with a cost transfer relocation clause in a residential context. Individually, each of these provisions is aggressive. Together, they are a very effective mechanism for limiting tenant recourse." Limiting your recourse, specifically, intentionally.
What this looks like when it goes wrong. I want to stop abstracting now and make this concrete. You are 71. You moved into your Tesla tiny house 14 months ago. The solar system is working, The Powerwall 3 is keeping your electricity costs near zero. You finally feel like you have stability. Then the fee notice arrives. Operational costs have increased. Your monthly fee is going up from $350 to $490, effective in 30 days. You don't agree with the increase. You want to dispute it. Under Clause 1, the lessor has the right to adjust. There is no cap. There is no formula to challenge. The adjustment is, by contract, within their authority. You want to take this to housing court. Under Clause 3, you can't. You agreed to binding arbitration. You'll need to file. That costs $400 before anyone hears a word you say. The arbitration is in a different state. You're on Social Security. You're 71 years old. You decide the fight isn't worth it. You'll pay the $490, but you start looking for a way out. Then the relocation notice arrives. The lessor is converting this section of the property to a different use. You have 60 days. Under Clause 2, the cost of moving that home is yours, all of it. You call 3 licensed transport companies. The quotes come back at $5,400, $6,100, and $7,200. You do not have a verified new site. You are paying out of pocket for temporary housing while you find one. You look at the other residents in the same situation. There are 9 of you. Under Clause 3, you cannot act together. You each face this alone. That is not a hypothetical. That is a contractual outcome available to the lessor at any time for any reason under the terms of this agreement. Who should not sign this lease? I want to be direct with you. There is no shame in this list. Knowing which category you fall into is not a failure. It is the most important decision you can make. Do not sign this lease without a real estate attorney reviewing it first if any of the following apply to you. Your monthly income is under $1,500 and you have no liquid savings to absorb an unplanned $5,000 to $8,000 expense. You have not confirmed in writing from a county zoning authority, not a sales representative, a written determination from the county zoning authority confirming that a structure of this classification can occupy that site for year-round habitation. If you cannot obtain that document, do not proceed.
Tesla doesn't build
Step
houses
3.
like projects.
Negotiate the escalation cap before you sign.
Surprise bills.
Ask in writing
a home
for an
that works
amendment
with you.
that caps annual fee increases to a defined percentage, 3%, 5%, any number tied to a benchmark. If the lessor will not add a cap, you now know exactly what kind of financial exposure you are accepting. That is your decision to make. Make it informed. Step 4. Request a modification of the relocation clause. Ask whether the lessor will share relocation costs in the event of a non-tenant caused displacement, zoning changes, land use changes, or lessor-initiated relocation. If they refuse, that tells you something important about the balance of this agreement. After you've signed, immediate actions. First, contact a real estate attorney in your state and have the lease reviewed now. It is not too late to understand your rights, even if it is too late to renegotiate. Second, document your current site status. Get written confirmation from your county zoning office that your current placement is legal. If zoning changes, that documentation is your starting point for any legal challenge. Third, start a relocation fund now. Begin setting aside a defined amount monthly, even $50, even $75, specifically for the possibility of a forced relocation. The worst time to need $6,000 is when you have 30 days to find it. Fourth, connect with other residents at your site. Even if the class action waiver limits legal collective action, a community of residents who share information, share legal costs where permissible, and document issues collectively is not nothing. It is often the difference between having leverage and having none. What this is actually about. I want to say something that has nothing to do with contract law. You are trying to stay somewhere. That is what this has always been about. Not the house, not the solar system, not the power wall. You are trying to make a decision at 68, at 72, at 76 that gives you somewhere to be for the next 10 or 15 years, somewhere nobody can take from you, somewhere your money lasts, somewhere the rules don't change under your feet without your consent. That is not a small thing. That is the whole thing. And the reason this lease matters, the reason these 3 clauses matter, is that they are the mechanism by which that stability can be taken away, legally, contractually, while you have no recourse and no one to fight alongside you. That is what I needed you to understand. The Tesla tiny house is not the problem. A home with 6 kilowatts of solar generation and a 13.5 kilowatt-hour power wall and composite panels rated at 260,000 psi, that is a serious piece of engineering. The problem is the piece of paper attached to the land beneath it. Read the piece of paper. Have someone who understands it read it with you. Ask the questions before you sign, because the most expensive thing you can say at 75 years old is, "I didn't think that's what it meant." You are buying this for who you are today. You're buying it for the person you will be in 10 years, on a fixed income, older, with less margin to absorb a mistake you could have avoided right now. Drop your state in the comments. If you've already signed this lease, or you're close to signing, tell me where you are and what your placement situation looks like. I read every comment. I will respond to as many as I can, and I'll use what you tell me to shape the next video in this series. If you're not subscribed, do it now. The next video is going to cover something no one in this space is talking about. What happens to the Tesla tiny house's Powerwall warranty and solar performance guarantee when the home is relocated even once? I talked to 2 separate Tesla energy service technicians to get the actual answer. It is not what the sales materials suggest. The next video, Powerwall relocation, warranty voidance, and the performance data from units that have been moved. If you're making a $10,000 decision with a $50,000 lease attached to it, you need to know what happens to the technical value of this home the moment that structure rolls off its original site. That video drops next week. This channel doesn't do hype, we do homework.